Good evening, sir.
Very good evening. All right. You've been a law graduate, right?
Yes, sir.
Uh, Tell me what is the basic fundamental thing in criminal law which is taught in the first hour of teaching criminal law, which is at the base of the criminal law.
Yes, sir. Uh, Sir, I would say that there are a couple of things, sir. The first of this is due process, which is the process should be just, fair, and reasonable. The second thing is, sir, presumption of innocence, which is that all are presumed innocent until proven to be guilty. And lastly, sir, what is taught in criminal law is mens rea, which is that an action is only blameworthy or criminal if it is done with wrongful intent.
This masseria is a Greek word or a Latin word?
Sir, it is a Latin word, sir.
Latin came first or Greek came first?
Uh, Sir, Greek perhaps because Roman Empire came after the Greek Empire.
You have any idea how many words of Greek and Latin are in Oxford English Dictionary?
No, sir.
Okay, tell me the fundamental difference between civil and criminal law.
Yes, sir. Sir, civil law pertains to a civil harm, which is a private harm that is committed to a party and it can be remedied by compensation. Whereas a criminal law is as to a criminal harm, which is a crime against society at large, which is why there is no compensation, but rather we have punishment of some kind. That is envisaged. The other difference is as to procedures. Sir. Civil law is pursued by the party that is harmed, and standard of proof is balance of probabilities. Whereas criminal law is pursued by the state on behalf of the party because it's such a grave harm, and therefore the proof is also much higher. Standard of proof is beyond reasonable doubt.
There are more differences than what you stated. What you stated is right, but not complete.
Yes, sir. In civil harms, intention is not always applicable. In criminal harms, intention is applicable. In civil, for civil law, sir, the courts are civil courts. For criminal law, there is the full criminal justice system with police, prosecution, defense, and a magistrate. Uh, Sir, lastly, I would say that the major difference is also the constitutional angle, which is that in criminal law, the life and liberty of the person are under question when we look at imprisonment and so on.
Then there are procedural differences
Yes, sir.
like evidence.
Yes, sir. Yes, sir.
What more? Yeah.
So, evidence, standard of proof, then
Hmm.
within civil, for civil law, sir, for commercial disputes, etc., disputes may be fast tracked and certain procedural technicalities might be left aside. However, for criminal law, there is a standard procedure under the BNSS, sir, that has to be followed.
Then plaint versus charge sheet.
Yes, sir.
Anyway, tell me what is the difference between judicial stamp paper and non-judicial stamp paper?
Sir, I'm not aware.
Tell me how the courts in India are funded. Who funds the courts in India?
Sir, to the best of my knowledge, sir, there would be two sources of funds. One is any fund that is disbursed under various schemes such as court modernization scheme, digitalization of court scheme, infrastructure upgradation scheme, etc. The other is that the court itself takes a fee for per litigation, which is the filing fee that is taken, sir. So that would be the two ways.
Uh, you have told the source of the, the collection of revenue through actually what is called judicial stamp papers because fees is taken in the form of judicial stamp paper. Tell me how the money is collected and distributed in the entire legal system from the smallest court to Supreme Court of India.
Sir, I'm not aware, sir.
You're not aware of who administers, who collects, and who administers the money to the legal system. That you're not aware.
Yes, sir.
Okay, as an IRS, which are the laws you're supposed to handle?
Sir, I'm an IRS income tax officer. So the first law that we look at is the Income Tax Act 1961. Outside of that, sir, we also look at the Black Money Prevention Act as well as Benami Properties Act. And in some instances, we flag instances of the PMLA as well. And we send it to the ED or other agencies.
Can you compare and contrast Cayman Island with Mauritius as a tax haven?
Uh, Sir, To the best of my knowledge, they are both places where very little tax is given, and companies seek to shift their base to these places in order to show that profits were in fact earned at that haven rather than our country or other tax jurisdictions. But I'm not aware of the difference.
Now, theoretically, tax haven is that what you are describing, but tax haven includes even Singapore and Dubai for that matter. But people go to Mauritius, people go to Channel Island, people go to Cayman Island, and all those places. What is the difference? What is the reason? That's the question.
Sir, if you're looking at certain jurisdictions being preferred, sir, firstly, it would be the effective rate of taxation. Secondly, if you're going to places like Cayman Islands and not Singapore, it would also be the scrutiny that is attached to transactions. So a
Hmm.
place might be zero tax, but one might still have to give an account of one's ledgers and the transactions done. In jurisdictions like Cayman Island, perhaps, that scrutiny is not there. So even if one is trying to hide the proceeds of crime or trying to hide the proceeds of business other than the one that is being claimed, all of that would be much easier in such jurisdictions.
Did you read Hindenburg report?
No, sir.
Why not?
Uh, Sir, I really should get down to reading it, sir.
Do you know the crux of the Hindenburg report?
Sir, I cannot recall.
You have no idea about that. What is round tripping?
Sir, round tripping is a business practice where one seeks to, sir, so it could be one of two things. I don't fully remember which one it is. One is investment. In investment treaties, what companies do is that where a domestic investor tries to send their money out and then through foreign subsidiaries and foreign incorporated companies, they try to invest back into India to claim benefit under investment treaties. And sir, the other is where the source of fund is diverted in a similar manner in the sale of goods and services.
All right. Tell me, I want to send a remittance of say 1 crore of rupees in dollar terms to USA. Okay. And my money is already tax paid money. On top of that, I pay 20% TCS. Now, is it justified? Can you take a stand on that as a officer that whether that is justifiable or not?
Sir, I would say based on whatever we've been taught in the past month, which is when I began training, sir, uh, it seems that there is a measure of double taxation in that once your income has been taxed, then it is merely the application of income which is taking place when you're sending your income to someone else. It's not income that is being generated anew. The most we can do is, as the state, we can charge a fee for conveying this income to another entity which is across the border. But, sir, double taxation does not seem to be accurate given that your income is taxed already.
No, I think you've taken the question to a different direction. It has nothing to do with earlier question. I'm talking about a plain single outward remittance, foreign remittance, outward foreign remittance, which I am sending, for example, to my son in USA, say a sum of rupees 1 crore, which is the tax paid money already. On top of that, they are deducting 20% TCS. I'm talking about that situation. So it's nothing to do with the double taxation and all that. So I'm just asking you that question. That is 20% TCS justifiable? It's just raised 2 years back would be.
Yes, sir. So,
2 or 3 years back. Yeah.
sir, concerning the 20% TCS,
Yeah.
given that your income has already been taxed once in whichever bracket it would fall under, now this income is only being applied to you for various sources. So it could be consumption, it could be anything else. The transfer of the income, which is already taxed once, should not be taxed again because there is a principle that we do not tax the same income twice. Sir, in light of that, ideally it should not be taxed. The most we can do is charge a fee for conveying this income across the border, sir, to your son. But we shouldn't tax it anew, sir.
All right. Thank you.
Ishan, you are already in Group A service, income tax. Why you are giving preference to another Group A service, that is customs? Is there a specific reason?
Sir, at the time that the preferences for services were given, this was in January 2025, at which time I had not joined training for IRS-IT. So at the time, I spoke to certain service seniors who said that I should put in customs to keep my options open. However, I found that I like direct taxation quite a bit now and would not be opting for customs.
You are LLB, right?
Yes, sir.
Uh, what is the reason for such a huge pendency of courts pendency of cases in the courts. Litigants are responsible, advocates are responsible, or courts are responsible?
Uh, Sir, the answer to your question lies in the question itself. It is all three in some ways. So, if we look at supply side factors, we would say that the courts are responsible in that vacancies are not filled in a timely manner, various judicial examinations are not conducted in a timely manner, and jurisdictional thresholds are enlarged. So, SLPs, for instance, the threshold is so enlarged that most of the Supreme Court's workload comes from the SLPs. When we look at litigants and advocates, sir, there is a culture of taking lots of adjournments, improper documentation that leads to further adjournments and retrials. And lastly, sir, there is not enough adoption of an ADR culture, where a lot of disputes can be handled before they go to a court as well, through mediation, arbitration, etc.
If given the chance, what measures you will take to reduce this pendency?
Sir, I would look at three broad ideas, sir. The first is law reform. The government has already been doing it through the simplification of labor codes, etc. But there are certain laws such as Negotiable Instrument Act, where check bouncing is a huge area. So, firstly, simplify laws and look at specific areas that are causing litigation and either simplify or rationalize the same. Secondly, sir, we have to look at pendency and we have to look at vacancies systemically. So, an all India judicial service for appointments would take care of vacancies. Lastly, sir, concerning the litigant culture, we have to fix proper timelines for the submission of plaint, etc., which are usually non derogable from. And therefore, we have to ensure that all specific evidence that has to be submitted is submitted in time by the parties. Lastly, sir, I would also promote various ADR mechanisms like arbitration, like court attached mediation, etc., so that issues that can be solved by the parties themselves do not reach the court at all.
Has Supreme Court taken any initiative on this line?
Yes, sir. Sir, the Supreme Court has ordered for attached mediation cells, which is also in line with what the Mediation Act 2023 looks at.
Ishan, what is common in Golaknath case, Sajjan Singh case, and Keshwanand Bharti case?
Yes, sir. Sir, Sir, Golaknath case, Sajjan Singh case, and Keshwanand Bharti case all talk about constitutional amendments and what kind of constitutional amendments are permissible. Earlier, the position was that constitutional amendments do not constitute law under Article 13 and therefore there is no restriction. Golaknath case said that Article 13 includes constitutional amendments, which means that a constitutional amendment cannot violate the fundamental rights. Keshwananda Bharti came in and said that we can even amend the fundamental rights, but the basic structure of the constitution must not be changed in any amendment.
What is this basic structure of the Constitution?
Yes, sir. Sir, the basic structure of the Constitution refers to foundational principles of the Constitution, like liberty, equality, fraternity, uh, as well as secularism, as well as sovereignty, territorial integrity, as well as federalism. These are principles that must not be derogated from whenever the Parliament is amending the Constitution.
Who preside over the joint session of the Parliament?
Sir, the speaker presides over the joint session.
How will you explain importance of law to a layman?
Sir, to a layperson, I would try to emphasize two things. One is that all of us have rights. So, whenever, if the layperson wants to know something from the government, they will use their RTI. When they're walking on the road, they have the right not to be trampled by the other person. Whenever they have somebody does any damage to their property, they have the right to get compensation. So, there is right, which is what the law guarantees, and there is procedure, which is who do you go to when any of your rights are infringed. So, do you go to the court? Is there a grievance redressal body? Where is it that we go? So, those two ideas of a right and there being a remedy for every violation of a right, I would explain in this way, sir.
Coming to your service, should farmer be brought into the income tax net?
Sir, sorry, sir, I could not hear the.
Should farmers be brought under the income tax net?
Uh, Sir, so for that we'll need a constitutional amendment because as of now, agricultural income is specifically exempt from the purview of the union. But I do believe that it should be brought into the act for large farmers and corporate ownership of farms. And that is because there are some CAG reports and the Kelkar Commission report also that mention that for very large land holdings and for corporate ownership of farms, a lot of non-agricultural income is also shown as agricultural income and is therefore getting exempted. So above a certain threshold, yes, sir.
You said it needs constitutional amendment. Which part of the constitution needs to be amended?
Sir, so Article 246 gives the three lists, and in list one of the entries, I remember entry 82, but I cannot be sure, sir, which says personal income brackets except agricultural income. So that entry 82 in list 1 will have to be amended, sir, in order to bring this under the purview of the Income Tax Act.
Thank you, Ishan.
Mr. Ishan, before I ask you a couple of business questions, just one thought. Negotiable Instrument Act, has it become outdated and redundant or no? It's one of the oldest business laws in the world, of course.
Sir, I would say that we should look at seeking to. I would say that parts of it are redundant for sure, sir. So, for instance, check bouncing has a very elaborate procedure which can be greatly simplified. The other thing is that it talks about many kinds of negotiable instruments like hundis, etc., etc. Not all of them may be in prevalence right now, sir.
All right. Now, a couple of business questions. Tell me, what is the basis of picking up Fortune 500 companies?
Sir, I would imagine it's their market capitalization.
You imagine, or is it a fact?
Sir, I haven't looked into the basis, sir.
You're not sure about it?
No, sir.
Are you aware of the market capitalization of Bombay Stock Exchange and National Stock Exchange?
No, sir.
Which is the biggest company in the world?
Sir, it used to be Apple at one point, sir, but I don't know, sir.
All right. Thank you. Your formal interview is over.
Yes, sir.